So you want to file a suit against Kaiser because you or a loved one has been harmed or killed. I am sorry. Well, here is what you need to get together to show an attorney just to see if he will take the case. Gather your medical records. Order them immediately from Kaiser following your state's request for medical records procedures. Instructions and sample forms are at harp.org/recordmethod.htm. Do not tell Kaiser or let them know what your intentions are. You may be taking a chance of having your medical records altered by the medical legal department before you receive them. If you do, with as little emotion as possible, write out a concise statement of what took place. If possible, also write out a timeline. Your first question to any attorney should be, do you or have you ever represented an HMO? If the answer is yes, then ask questions about the attorney's involvement with the HMO or find someone else. Their loyalty may not be with you. Realize that all victims of the Kaiser system feel that their case is unique and will be the one that will make change. The truth is that only by having all cases made public will any change be made. The Kaiser arbitration system will not as a rule make this information available to the general public. Read the webpage How to Survive a Kaiser Arbitration at the Kaiser Papers in the legal section. This page is not well written, but it certainly presents the truth. Make sure you go into this with open eyes. Also be sure to read the material at harp.org. A Kaiser arbitration costs more money than a conventional court proceeding. Whether the client foots the bill or the attorney, it is rare to do much more than recoup your expenses. True justice in this form of legal proceeding is rare. No one can bring back your health or a loved one's life. This is a closed civil proceeding that probably will never see the light of day. Realize that from the start. The hardest part as a victim of medical negligence or malpractice or as a survivor of a loved one wrongfully killed is being told that a person's financial worth is based upon their potential earning capacity. If you are very young and die, or if you are elderly, that is not very much money. It is not fair, nor is it morally correct, but it is what the law says and none of us can do anything about that. The following is extremely important as Kaiser hopes that you will not learn about it. A California appellate court has ruled that a mandatory arbitration agreement is not binding on adult children suing for wrongful death of a parent. The case is Buckner v. Tamarin, California 2nd Appellate Case B14938-5. Who will be bound by the patient's agreement to arbitrate? 1. An agent can bind a principal. 2. Spouses can bind each other. 3. A parent can bind a minor child. If you have Kaiser insurance through your employer, it is an ERISA plan, and you cannot be forced into arbitration. Government at all levels and church employees are not subject to ERISA. Regulations make it clear that ERISA plans may not require mandatory arbitration. However, Kaiser is likely to ignore these regulations and refer to the contractual provisions that require arbitration, so it is important that you are very clear about your ERISA rights so that you can enforce them. The Department of Labor can clarify any questions about this under ERISA plans. Their website is dol.governor/EBSA/ERISA_enforcement.html. The specific regulation is 29 CFR 2.560.50-3-1. Under Item C, Group Health Plans, it states, the claims procedures of a group health plan will be deemed to be reasonable only if, in addition to complying with the requirements of Paragraph B of this section, 4. The claims procedures do not contain any provision for the mandatory arbitration of adverse benefit determinations, except to the extent that the plan or procedures provide that. Best wishes, and I hope that you have the best of luck.